Welcome to Just Settled. On today's episode, we have Logan Quirk, the founder of Quirk Accident and Injury Attorneys out of Thousand Oaks in Los Angeles. Logan, thanks so much for being on Just Settled, and we welcome you to the show.
Thank you for having me today, Dan. It's a pleasure to chat with you.
Awesome. So Logan, you're a PI attorney here in LA. We kind of gave me a brief overview before of this specific case that you were working with. It's definitely an interesting one and not one that I've actually had an episode on yet. So I'm glad to kind of dive into it and get your take on everything. Can you give us sort of the overview of what happened in this case, how you first learned about it, how it first came across your desk?
Sure. So the client came to me. He had tripped and fallen at his house. He lived in an ADU of a private residence here in Los Angeles. The landlord had a few properties she rents out. Sorry, the puppy's squeaking back here. And he hit his head. So we were concerned about a TBI. And with these cases, liability is always, it's not uncertain, but it's not as concrete as a car accident case where there's often a rear end case and liability is pretty clear. But we really liked the client. He was a really nice gentleman. So we decided to sign him up, got him into some treatment, some diagnostic imaging, and some testing to diagnose his TBI. And fortunately, he was able to come through and recovered pretty quickly. So we work with excellent medical providers that were able to help him out. And once he was done treating, we started getting all the medical records and bills and all the other statements and necessary evidence to make a demand. And we sent off a demand and began the discourse with the insurance company.
When you say ADU, can you just, for the audience, kind of describe what that is for anyone?
ADU is kind of like a granny flat. It's like a second home in the back of the property. Some people convert them from garages. I think they got really common in COVID, being like she sheds. So a lot of landlords in Los Angeles have these secondary structures that are often garages or second homes on their property, so they convert them into rentable units.
Okay.
I know it's terrible. Sorry.
That's okay. So, yeah, did you have concerns or uncertainties about this case? Was there anything that in terms of like the potential outcome that you were worried about or just not worried about, but knew might be hurdles here?
I don't, there's some firms that won't take on premise liability cases because it's not within their firm model or threshold. I don't have a hard and fast rule with that. I really liked the client, but liability again was not concrete, not certain. So we definitely had a little bit of a, I wouldn't say a concern, but it was definitely an issue. The other issue were the damages, and with TBI, that's kind of a subjective quality or measurement with insurance companies. With recent advancements, there's a lot of testing that helps give objective data and metrics to show the nature and the extent of the TBI. So we were able to get them in right away to help bolster the claim.
Gotcha. Okay. What were the client's sort of expectations in terms of restitution? Just, kind of ballpark figure. What did you see as like an estimated value of this kind of case? Like, what is the range that someone might be looking at?
The range for TBI cases can be really high, 7 figures, sometimes 8 figures, just depending on the permanency of the damage.
Yeah.
This one, because he had recovered quickly, I won't say he recovered in a few days, but within 6 months he was feeling better. So the range of this was probably a 6-figure case. And then factoring in liability, we were hopeful of a 6-figure resolution, and we were able to exceed our expectations. The client really did not come to us with a monetary expectation. He knew that his recovery was going to be a dollar figure because it's a civil case, but he didn't have any, I want X amount in my pocket, or I want to settle for this amount. So it's always nice when clients come to you and don't have that as their end goal, because sometimes some people may inflate the value of their cases depending on what Uncle Bob settled for or neighbor Sally settled for. So he was a really good client. We were very fortunate to have a really good client and a healthy insurance policy.
Want to share your settlement success stories? Join us as a guest on the Just Settled podcast. Visit our Instagram at Just Settled Case and click on the link at the top of the page to set up your interview today. In terms of typical opposition obstacles, I know in any case like this, there are certain things that you're always going to come up against. What were some of those? And then were there unique challenges or anything that was sort of a curveball that you may not have seen coming in the beginning that kind of rose up during the proceedings?
This, with these cases, I anticipate that they will require litigation just because insurance companies usually will either offer a very low amount or deny liability. And so we will file to get the file transferred to a new adjuster and get an attorney on the file. So I had that expectation going into this, but once we sent the demand package, the following emails from the handling adjuster were hinting at a settlement coming, and the emails were hinting at a policy limit settlement coming. So we had to cross our T's and dot our I's with that. We got an offer and we negotiated it and we were able to get a number, and then there was an umbrella policy. But once I got dug into it a little bit, the insurance adjuster that was handling the umbrella policy did not evaluate the case as highly as the primary adjuster did on the bodily injury liability policy. So that presented an opposite dynamic for me in that I had to consider, if I put this case into litigation, will this offer be reduced or taken away? Will liability be reevaluated and we're stuck at square one? So in this, I actually counseled the client to accept the settlement, which was very fair and a great result for him, because I didn't think the risk was worth going into lawsuit and litigation and opening that can of worms and exposing that potential outcome for him to have a lesser settlement. So that doesn't happen too often in our practice, where going into litigation you expect the offer to be lower or expect the result to be lower. But that's something we have to be mindful of, and especially on premise liability cases, because two sets of eyes can look at things completely differently.
Right. Can you kind of outline the timeline of this case from start to finish? What did that look like?
Sure. I jotted down a note. We retained the case in early 2023. He treated up through, I want to say, third quarter, late 2023. Got all the evidence, the medical records, made a demand package in early 2024, and then the first half of this year we were able to negotiate a settlement. So say 12 to 18 months was a time resolution on this case.
Pretty quick turnaround. What point did you realize like a settlement was likely? You mentioned that earlier, touched on it, but instead of going to trial here, when did you kind of know we can go to settlement?
I once I got the offer and I started talking with the other adjuster, trying to verify that the umbrella policy would apply to this case, I was getting excited because I was like, oh, there's another pot of money. But in those conversations, I listened to the adjuster and what she was telling me, and she was hinting that she didn't like this case, and she didn't think that the first adjuster had evaluated it fairly, and had possibly and actually did over evaluate the case. So that was a big red flag for me about pushing this into litigation. And as personal injury attorneys, we always want to maximize our clients' results, but we also have to be mindful that sometimes if we push too much, we are going to be an impediment to settlement or a detriment to our clients' bottom line results. So this was one of those cases where a more measured approach was the reasonable and the best thing to do for the client.
And how did sort of that negotiation process unfold? Because I know defendants or insurance companies, they're always trying to minimize compensation. How did you advocate for your client's interest in this case?
So we did a normal policy limit demand. We wrote it and attached all the necessary documentation and made it pretty airtight, outlined the damages, the future damages, the pain and suffering damages. And we had a good rapport and relationship with the first adjuster, and she was very, very easy to deal with on this case. So contrary to my normal dealings with insurance adjusters, she was actually a very reasonable person, and it was very delightful to actually have someone who's not fighting you tooth and nail on everything. However, the second adjuster was more in line with my experience with insurance companies and insurance adjusters, where they're trying to minimize and tell you your client, is overpaid, over treated, and the damages aren't what you think they are. So it was kind of the reverse of my normal course of dealings with insurance companies, and that's kind of the outlier in our industry. But when you get that, I won't call it a gift, but when you get that person who actually is being reasonable, you don't want to push them away or push the opportunity to settle at a decent amount away just because of your past experience. You want to be able to be nimble and pivot and make good, thoughtful, and diligent decisions based on the facts and the opportunity and the what's in front of you.
And I know you said the settlement amount here is confidential, but in terms of the final outcome, can you kind of just give us a general sense of what that looked like and then how that positively impacted your client after the case kind of resolved?
Definitely. We settled for policy limits. It was a six-figure settlement. The client was able to take away six figures in his pocket, and he was over the moon with that. And he's going to be able to use that money to make a impact on his life, and how he chooses to spend that money is his discretion. But knowing the client, I know he's going to spend it wisely, and it's going to definitely improve the quality of his life. He was going from renting a ADU unit in a back house to now having the opportunity to move to a new place, to put some money away, maybe buy a house or spend it in a way that's going to better his life.
In today's digital landscape, a strong social media presence holds significant importance for legal professionals. Recognizing this need, Practice 360 by LegalSoft is pleased to announce an exclusive promotion offering a comprehensive law practice social media solution free of charge for 30 days. Practice 360 is the all-in-one solution to elevate your law firm. Access a suite of services including personalized mobile apps, website development, PR, and social media management. With everything centralized, say goodbye to juggling multiple providers. Elevate your firm's success with Practice 360 today.
So they're very, very lucky to have come across you for this case, Logan. Thank you so much for sharing the details of this case with us here today on Just Settled. Again, for anyone, this is Logan Quirk, amazing attorney out of Thousand Oaks, Los Angeles, founder of Quirk Accident Injury Attorneys. Logan, you want to tell the audience where they can find you?
Sure. You can find me on Instagram, Facebook, YouTube, and my site, quirkwins.com. We have all the links in our socials, and we have a pretty active social presence, and our team does a phenomenal job of maintaining that and trying to get us out there and give some valuable content to the users and whoever's subscribing and interacting with us. We love it. So find us at Quirk Accident Attorneys or Quirk Wins on TikTok as well.
Awesome. Well, thank you, Logan, and we hope to have you back on Just Settled soon.
Thank you, Dan. I appreciate the opportunity.